For essentially every industry of society, court rulings establish legal precedent that shape key issues. And this is no different for the insurance industry. So it's meaningful if you or your business has a claim to understand how certain cases can influence the outcome of that claim. Now, there are hundreds, even thousands of court cases you could examine for insights. Today, I'm just going to take three and look at their significance. Let's dive in. The first case we're going to look at is the 1981 case Keene Corp versus Insurance Company of North America. Keene Corp was a manufacturer of asbestos-containing products, and after individuals who had worked with their materials suffered bodily injury, they sought insurance coverage from Keene's commercial general liability insurers. CGL insurers had issued policies for Keene from 1961 through 1980, and Keene had manufactured the products at issue from 1948 through 1972. Because CGL policies are triggered when bodily injury occurs during the policy period, the court was required to determine when asbestos-related bodily injury occurred, to determine which policies provided coverage. Keene argued that bodily injury occurred and its CGL policies were triggered whenever a claimant was exposed to asbestos and during the subsequent development of disease. The insured argued that the body incurs microscopic injury when asbestos fibers become lodged in the lungs and as the surrounding tissue reacts to the fibers, as the injury or health issue progresses. The insurers argued alternatively that only the policies in effect at the time of manifestation of disease or at the time of asbestos exposure were triggered, but the progression of asbestos disease did not trigger coverage. The Keene Appellate Court held that the initial exposure to asbestos, the time during which the asbestos fibers were in residence in the claimant's lungs, and the manifestation of disease all triggered coverage. As the court explained, we interpret bodily injury to mean any part of the single injurious process that asbestos-related diseases entail. Regardless of whether exposure to asbestos causes an immediate and discrete injury, the fact that it is part of an injurious process is enough for it to constitute injury under the policies. Keene was the birth of the continuous trigger, which has cost the insurance industry billions of dollars for latent injury and damage claims, such as asbestos, silica, and hazardous waste. More recently, a number of other chemical products are on the radar as progressive injury agents. The continuous trigger has altered the general mindset of insurance coverage analysis. Attempts to treat all kinds of claims, even for non-latent injury, as continuous is now very common. Based on Keene and all that came after it, policyholders now take a continuous trigger approach to coverage whenever possible to receive maximum compensation from policies. Keene is also part of legal precedent for how to allocate legal damages when multiple policies are triggered for a continuous injury. For example, if an injury occurs over a 5-year span during which 3 different carriers covered liability insurance, the Keene case may offer guidance as to which carriers should respond. The next case to examine is the 1929 case G.A. Stowers Furniture Company versus American Indemnity Company. American Indemnity Company issued an auto liability policy to G.A. Stowers Furniture Company with a limit of $5,000. When one of their trucks was in a wreck, American Indemnity refused to pay the full $5,000 to settle the claim. The insurer reasoned that it had little to lose if they had to go to trial because its liability was limited by the terms of the policy, $5,000 in this case. Sure enough, the insured exceeded the $5,000 limit and eventually needed to pay upwards of $12,000 to the injured party. G.A. Stowers Furniture Company sued the American Indemnity Insurance Company for negligent failure to settle the claim when they had the opportunity. The case eventually went to the Texas Supreme Court, who sided with Stowers. In doing so, they established a standard of care and ethics that adjusters must follow in evaluating claims. Stowers is the best known case to adopt the hugely important rule of bad faith failure to settle. In general terms, if there is a settlement demand within policy limits such that an ordinarily prudent insurer would accept it, and the insurer fails to do so, and then the case proceeds to trial, the insurer is then liable for the entire amount of the judgment, including the amount exceeding the insured's policy limits. As a result, insurance carriers are kept in check to act ethically when settling claims. This case is particularly applicable if a policy has low limits, such as a personal auto policy with state minimum limits, or policies that incur catastrophic damage, such as bodily injury that exceeds $1 million. In either of these cases, it's reasonable to see an insurer being unwilling to pay the full liability limit unless there was a worse outcome that could come as a result from a court ruling. The so-called Stowers Doctrine exists in some way, shape, or form in just about every state in the country. The last case to examine is the 1982 case Appalachian Insurance Company versus Liberty Mutual Insurance Company. Liberty Mutual was accused of gender-based discrimination by many employees in their claims department. Some individuals alleged multiple counts of discrimination. The question arose as to whether there were many occurrences or just one. The court noted that if there were multiple occurrences, the $25,000 retention per occurrence would mean that the Appalachian policy would never respond because no single class member, as part of the settlement, had received a distribution in excess of $25,000. The employees brought their charges in May 1971 before the Equal Employment Opportunity Commission, alleging that certain employment policies that Liberty adopted in 1965 discriminated against women. These claimants on February 28, 1972, filed a class action allegation. The plaintiffs alleged that Liberty committed sex discrimination in its claims department in hiring, promoting, and compensating females. The case made it to the Third Circuit Court of Appeals, which held that the injuries for which Liberty was liable all resulted from a common source, Liberty's discriminatory employment policies. Therefore, the single occurrence, for purposes of policy coverage, should be defined as Liberty's adoption of its discriminatory employment policies in 1965. The fact that there were multiple injuries and that they were of different magnitudes and that injuries extended over a period of time does not alter our conclusion that there was a single occurrence. As long as the injuries stem from one proximate cause, there is a single occurrence. A lot of insurance litigation has taken place over the issue of number of occurrences. Whether injury or damage was caused by one occurrence or more can have a monumental impact on the extent of an insurer's liability for a claim, an insured's deductible or retention, and the amount recoverable for underlying plaintiffs. Many decisions address the two competing theories, the cause test, which usually results in a single occurrence ruling, and the effect test, which often yields a multiple occurrences ruling. In this case, the court held that despite there being claims by several individuals, the injuries for which Liberty was liable all resulted from a common source, Liberty's discriminatory employment policies. Therefore, the single occurrence, for purposes of policy coverage, should be defined as Liberty's adoption of its discriminatory employment policies in 1965. Appalachian v. Liberty Mutual has been nationally cited on numerous occasions and has been at the heart of many cases to adopt the cause test, which is the majority rule nationally. So there you have 3 court cases that have significantly influenced the insurance industry and how a claim gets settled. Stow this info away for the next time your business faces a loss. Hopefully that won't happen anytime soon, but if it does, you'll be better prepared with this knowledge handy. Thanks so much for watching.